Welcome back to The Deep Dive, the show that extracts the crucial insights from complex material, giving you the shortcut to being well-informed.
Today, we are strapping in.
We really are. We're taking a high-level flight over the legal landscape of civil procedure.
And this isn't just, the administrative stuff.
No, not at all. This is the operational code for the entire judicial system. And as aspiring legal professionals, you know that the substantive merits of a case, the question of who is right, can be utterly destroyed by failing the non-negotiable requirements of procedure.
That's right. If the engine room is broken, the ship isn't sailing.
Exactly.
And this deep dive is, it's tailored specifically for you, the third-year law student. We're focusing on where theory meets the sharp edges of practice when you're initiating a suit.
We're looking at the Ethiopian Civil Procedure Code, the CPC.
Yes, dissecting those fundamental stages, right from the initial filing, the pleading, all the way through to that high-stakes moment of serving the other party. This is really where you learn how to avoid the fatal technical errors that get a case dismissed.
Or worse, a costly retrial.
Or worse, a costly retrial.
And we have to start by offering our professional thanks and acknowledgement to Mr. Abdurahman's side.
A respected lecturer and lawyer.
Absolutely. His comprehensive lecture notes really form the foundational roadmap for the extensive detail we're about to unpack.
So thank you, Mr. Side, for providing such clarity on this crucial subject.
So our mission today is pretty comprehensive.
It is. We are unpacking 4 pillars of procedural foundation. First, pleadings, the anatomy of the claim, and the defense.
Then we'll get into the strategic constraint of splitting of claims.
After that, the mechanics of the institution of suit, and finally what I think is the ultimate procedural hurdle, service of process.
And for that last one, we'll be focusing heavily on its due process implications.
Yes, drawing directly from some really important cassation bench rulings.
Okay, let's start with the cornerstone, pleadings. When a client walks into your office with a grievance, the pleading is the filter that transforms that messy reality into a legally actionable format.
It is.
So what is the formal legal definition we're working with here?
Well, the definition, as laid out in Article 81 of the CPC, is actually quite broad and inclusive.
Okay.
Pleadings are defined as all formally written statements filed by the parties.
All of them?
All of them, concerning their respective claims and their defenses. So it encompasses the obvious things, the initial statement of claim, the statement of defense.
Right, the SC and SD.
Exactly.
Yeah.
But its scope extends far beyond that. We have to remember it also includes a counterclaim, a set-off, any subsequent replies, memorandums of appeal.
Even specific applications or petitions.
That's right. If you are presenting your side of the dispute to the court in writing, it's a pleading. Simple as that.
So given this rigorous requirement for formal written statements, what are the core functions they serve? Why all the formalism?
The functions are just vital to the fairness and the efficiency of our adversarial system. There are probably 5 primary roles. First and most basic is notice. The pleading formally notifies the opposing party, the defendant, of the specific claims against them.
So they can prepare a defense.
Exactly. It's a fundamental due process requirement. Second, it gives the court a clear, concise summary of the dispute. It sets the parameters.
And third, you mentioned this is critical for the trial judge. It's about fixing the issues.
It is. The pleadings fix the specific issues that must be decided during the trial. The judge isn't meant to just, wander off on tangents. The pleadings narrow the scope of inquiry.
So they act as a kind of procedural guide.
A guide, right, dictating the subsequent steps for everyone. And finally, by forcing that early clarity and narrowing the field of dispute, they're instrumental in expediting litigation. They prevent you from wasting time presenting evidence on facts that nobody is even arguing about.
That concept of fixing the issues is so key. It's almost like a contract between the parties and the court on what the fight is actually about.
That's a great way to put it.
Now, to achieve that clarity, you mentioned a pleading has to satisfy 2 sets of rules: technical requirements for format and legal requirements for substance. Let's start with the technical ones. They're often the easiest mistakes to make.
They really are. The technical rules govern the physical presentation and preparation of the document. It's about making sure it's legible and administratively sound.
We're talking about Articles 82 to 222, 223, and so on.
234 and 327 through 330. So, for example, Article 82 dictates the physical medium.
Like handwritten in ink, printed.
Or typewritten on prescribed paper. It seems mundane, but courts often have very specific requirements for paper size and quality to make sure documents bind properly and, frankly, survive for years in a file.
And the language has to be concise.
Concise, clear, precise, and plain. We're aiming for legal clarity, not, literary flourishes.
This brings us to what might be the most frequently cited mantra in procedural law. Plead facts, not law, and not evidence.
Ah, yes.
For our audience, this distinction is absolutely paramount. But where do lawyers often stumble in practice?
This rule, that you must state only the material facts you rely on, is the true acid test of a good lawyer. You have to exclude legal provisions or arguments.
That's for later.
That's for oral arguments and legal memos, after the facts are established. And you must exclude detailed evidentiary matters.
So you don't say who will prove a fact or how they'll prove it.
Exactly.
Okay, give us a robust example of where that line gets crossed.
Certainly. Let's take a negligence case, a car accident.
Okay.
The material fact you must plead is something like, on June 1st, 2024, at 4:00 p.m., the defendant drove a blue Toyota, license plate X, at an excessive speed of 100 kilometers in a 60-kilometer of zone, causing it to collide with the plaintiff's vehicle at the intersection of Bull Road and Africa Avenue.
That's a statement of fact. Duty, breach, damage, it's all there.
It is. Now, what you must not include is the law. So you don't write, under Article 2028 of the Civil Code, this excessive speed constitutes a fault. That's legal argument?
And you also don't include the evidence.
Right. You don't say. The police report, which will be Exhibit P1, clearly shows skid marks consistent with the defendant's excessive speed, and our witness, a traffic engineer, will testify to the impact dynamics.
Because those are all evidentiary issues for the trial itself.
Precisely. Failing to maintain this boundary just confuses the court. It prejudices the other party by forcing them to respond to arguments prematurely, and honestly, it often leads to the document being deemed insufficient under Article 91 for containing improper matter.
Okay, beyond the content, what other technical boxes need to be ticked? Verification and signatures.
Essential. The pleading has to be verified under Article 92.
Meaning you confirm the facts are true to your knowledge.
Yes, and it must be signed by the party or their authorized pleader under Article 93. And a major practical pitfall is often the annexes.
Right, Articles 223 and 2554.
You must attach a list of your witnesses, full name, address, and the specific purpose for which they are being called, and a comprehensive list of every single document you intend to rely upon.
And people mess this up.
All the time. Missing addresses, vague purposes for witnesses, or trying to introduce a documented trial that wasn't on your list. These are common procedural failings that can just hamstring your case before it even starts.
So, when the statement of claim is handed to the court, who is the first procedural gatekeeper? And what happens if these technical rules are missed?
The first gatekeeper is the registrar. Their job is purely administrative review.
Okay.
If the registrar finds that the technical requirements, like proper format, verification, or complete annexes, are not complied with, they have the authority to reject the statement of claim under Article 229.
And is that the end of the road for the case?
No, and this is crucial. Rejection at this stage is a temporary setback, not a death blow. Article 232 clarifies that rejection for technical defects does not bar the plaintiff from bringing a fresh pleading later.
As long as you fix the defect and refile.
Exactly. Once the registrar is satisfied, the file is passed to the judge.
The judge then performs the legal requirements check. What are the two non-negotiable substantive checks the judge performs immediately?
The judge is looking for the two pillars of judicial action: cause of action and jurisdiction. Article 231 mandates that if the statement of claim fails to disclose either of these, the suit shall be rejected.
So if the facts, even if we assume they're true, don't entitle the plaintiff to any legal relief, or if the court simply lacks the authority to hear the case, it's over.
It cannot proceed.
Let's deepen that distinction on jurisdiction, because not all jurisdictional defects are treated equally at this early stage, are they?
No, absolutely not. We distinguish between non-waivable and waivable jurisdiction. The court must possess non-waivable jurisdiction.
That's jurisdiction over the subject matter, right? Like family court versus commercial court.
Correct. An exclusive jurisdiction over the court type. If the court completely lacks authority over the type of dispute, the judge can, and in fact must, reject the claim on their own initiative. Sua sponte.
But issues related to waivable jurisdiction pecuniary, the monetary value, and local, the geography, are different.
Very different. Those relate more to the convenience of the parties. And because the defendant has the right to waive those objections, the court has to wait for the defendant's reaction in their statement of defense before rejecting the claim on those specific grounds.
And if the claim is rejected at this stage for lack of cause of action or non-waivable jurisdiction,
Article 232 is clear. The court fee is refunded, and the plaintiff can file a fresh claim that addresses this substantive failure.
Okay, let's focus our attention now solely on the statement of claim. Article 222 provides a clear template detailing 4 essential elements.
That's right. The first is the caption. This is the administrative header.
So, name of the court, title of the suit.
And the full names, addresses, and status of all parties: plaintiff, defendant, any representatives. Precision here prevents a lot of confusion down the line.
The second is the most complex and contentious, the cause of action.
This is the very basis for the suit, detailed in Articles 222 and 231. The cause of action is, it's the set of essential facts the plaintiff has to prove to show that a legal right was infringed, and that this infringement deserves a remedy.
So for a breach of contract, you need to show the contract existed, what terms were breached, that the defendant failed to perform, and what damage resulted.
Yes. If your pleading omits any one of those elements, the cause of action isn't fully disclosed, and your case is vulnerable to rejection.
Third, we have the declaration of jurisdiction linking the facts of the claim to the court's authority.
Yes. Article 222 requires facts that demonstrate the court's authority. This means you have to specify the financial value of the dispute to establish pecuniary jurisdiction and describe the nature of the suit to confirm exclusive jurisdiction.
You're basically showing the judge, I have filed this 300,000 birr dispute in the correct court.
Exactly.
And finally, the fourth pillar, relief. This might seem obvious, but you mentioned a critical caveat regarding Article 182.
This is a professional trap for the unwary. Article 224 requires the plaintiff to state specifically the relief they're claiming, whether it's simple, like just damages, or alternative, like specific performance, or feeling that damages.
And the caveat.
Article 182, it states unequivocally, no court will grant relief unless it is specifically claimed by the party.
So if your client is owed 1 million birr, and your statement of claim accidentally only requests 800,000 birr,
the court absolutely cannot award you that additional 200,000 birr. The court cannot read your mind or invent remedies. You are limited by the prayer in your complaint.
Wow. So the lawyer has to be comprehensive, not just correct.
Precisely.
Let's return to the cause of action failures. Our sources outline 3 distinct ways a claim can fail to disclose a valid cause of action.
These scenarios are crucial for any lawyer to predict. First, and this is the most common, is when the allegations, even if they are perfectly true, just don't legally entitle the plaintiff to relief.
Maybe the transaction was legally void from the start.
Or the act complained of is statutorily protected. Second, the plaintiff pleads conclusions instead of material facts.
So just saying the defendant owes me 50,000 birr isn't enough.
That's a conclusion. You have to state the underlying facts: the loan agreement, the date, the failure to repay. And third, and this is probably the most embarrassing procedural error,
What's that?
the plaintiff alleges facts that affirmatively establish the defendant has a good defense, or that the plaintiff themselves isn't entitled to relief. You essentially provide the court with the grounds to rule against you based on your own filing.
You plead facts that show your claim is barred by the statute of limitations.
You've seen it happen. You're basically handing the other side the win.
Now we turn to the defendant's primary weapon. The statement of defense, governed by Article 234. What are the defendant's specific obligations regarding the plaintiff's material facts?
The defendant's duty is one of detailed engagement. The statement of defense has to contain all the material facts they rely upon. This means the defendant must deal with every material fact alleged in the statement of claim.
They can't ignore anything.
Can't ignore anything. They have to state any new facts in their favor. These are affirmative defenses, and they must list any legal objections they intend to raise.
Lack of jurisdiction, statute of limitation.
Things like that, yes.
Can the defendant simply say, I deny everything?
Absolutely not. Ethiopian Civil Procedure requires specificity. A general denial is not permitted.
With one exception.
One key statutory exception: allegations related to damages. You can generally deny the amount of damages claimed, and that forces the plaintiff to prove the quantum. But for every other material fact, the date of the contract, the location of the accident, the identity of the parties, your response has to be direct and substantive.
This leads directly to a procedural trap that can destroy unprepared defense cases. The danger of evasive denial under Article 235. What is this, and why is it so perilous?
This is one of the most punitive rules in the code, and it's designed to enforce honesty and efficiency. Evasive denial is when the defendant denies an allegation in general terms, avoiding a clear, specific answer to the point of substance.
Can you give an example?
Of course. Let's say the plaintiff claims the defendant received the payment in Addis Ababa on Monday, May 6, 2024.
Okay.
And the defendant responds, I deny receiving the payment on May 6th. That's evasive. It's ambiguous. You're not specifying when or where you did receive it or if you received it at all.
And the consequence of that evasive denial is procedural suicide.
It is an immediate admission. Under Article 235, an evasive denial amounts to an admittance of the fact alleged by the plaintiff.
So the court just takes it as proven.
Yes, the court will deem that fact proven and remove it from the issues to be tried. This saves the plaintiff the cost and effort of proving it.
Is there any way around that?
The only time the court can overlook an evasive denial is if the defense is made by a person under a legal disability, like a minor, or someone legally incompetent who might not fully comprehend the legal requirements.
Structurally, the defense can include more than just denial. It can introduce new actions, correct?
Yes. Beyond affirmative grounds of defense new facts that defeat the claim, like lack of capacity or res judicata, the defendant can file a counterclaim or a set-off.
A counterclaim is basically the defendant suing the plaintiff in the same action.
Yes, usually related to the same subject matter. And a set-off is a defense where the defendant asserts a debt owed to them by the plaintiff that can reduce or even extinguish the plaintiff's claim.
And what if the defense itself is procedurally defective?
Well, just like the statement of claim, if the statement of defense is insufficient or vague or evasive or technically non-compliant, the court may reject it under Articles 238 and 229. A weak defense is almost as dangerous as no defense at all.
It just opens the door to summary judgment.
Or severe evidentiary constraints.
Let's discuss the procedural safety nets, or lack thereof. When a lawyer omits a material fact or an entire claim, if a party omits facts that should have been alleged, they are essentially barred from introducing evidence on that issue at trial.
Unless they get permission to amend. That's the rule.
So without that permission, you can't raise new issues.
No, because those issues weren't fixed by the initial pleadings. The only practical exception is if the court decides sua sponte to frame issues based on material that emerges during the trial, or, and this is critical,
if the other side doesn't object.
Exactly. If the defendant fails to object to the introduction of a new issue by the plaintiff during the proceedings, the court considers that silence to be consenter and the issue may be heard.
We also have the concept of alternative pleadings. This allows a party to hedge their bets strategically.
It does. Alternative pleadings permit parties to rely on optional grounds to maximize their potential recovery or defense.
So a plaintiff might say, a valid contract exists.
Or, alternatively, if the court finds the contract void, I am entitled to unjust enrichment. And for the defendant, this freedom is even broader. There's really no limit on the number of alternative or even contradictory grounds of defense they can invoke.
As long as they're factually supported and relevant. And what about subsequent pleadings under Article 239? Once the claim and defense are filed, when can we file another document addressing that initial dispute?
Further pleading is highly restricted. The system wants to maintain pace and efficiency. It's generally allowed only when the statement of defense contains a counterclaim or a set-off.
Because then the plaintiff is now effectively a defendant to that counterclaim.
Exactly, so they must be allowed to file a reply to counterclaim. For any other simple defense, the court won't permit further pleading unless it's under the guise of an amendment.
And when a counterclaim is filed, the defendant becomes the plaintiff for that new claim.
And, importantly, has to pay the relevant court fees as per Article 215.2.
This brings us to the procedural lifeboat, the amendment of pleadings under Articles 91 and 252. This assumes a defect was found. Why does the CPC allow such flexibility?
Amendment is allowed because the law recognizes that, technical perfection is rare. Justice shouldn't be defeated by a technical error. It allows parties to rectify defects, add important allegations they miss, or even include a new claim that arose after the original filing.
The philosophy is to determine the real questions in dispute.
Not just the questions that were initially pleaded, that's right.
So what are the two core requirements for a successful amendment request?
First, the request must be made before the court renders a decision. Once judgment is passed, it's too late. Second, the court has to be convinced that the amendment is necessary for determining the real question in dispute.
So the court's function is to resolve the underlying conflict.
And if an amendment helps achieve that, it's generally granted. The court engages in a delicate balancing act.
On one side, the need to avoid delay.
And on the other, the fundamental goal of protecting substantive rights from being lost due to a simple human error in drafting. So courts generally adopt a liberal approach, favoring amendment if it serves the ends of justice.
But this liberalization has strict boundaries. When is an amendment Absolutely not possible. This is crucial for strategic planning.
The limits really define the boundaries of procedural fairness. First, an amendment cannot introduce a totally new and different cause of action that fundamentally changes the nature of the suit.
So you can't just change your entire case halfway through.
No. Second, you can't amend to change the underlying legal title or basis of the claim. For example, switching from a claim of ownership to a claim of usufruct. Third, if the amendment is purely technical and won't affect the ultimate result, it's unnecessary and will be denied.
And the fourth limit is the most critical one.
It is. You cannot use an amendment to prejudice the substantive rights of the other party.
And this usually comes up with the statute of limitation.
Exactly. If the new claim you're trying to add by amendment is already time-barred, allowing the amendment would illegally deprive the defendant of their accrued legal right to assert the defensive limitation. That is a guaranteed denial of the amendment request.
Finally, we covered instances where the court mandates the correction, the compulsory amendment under Article 91.
This is the court intervening to clean up the paperwork. It happens when a pleading, though maybe legally sufficient, is defective in its presentation.
So if it's not sufficiently definite, it's too vague.
Right. Imprecise allegations that make it genuinely difficult for the other side to respond. The court orders clarification. And Article 91(4) applies when the pleading contains improper matter.
Scandalous, unnecessary.
Or material that will prejudice, embarrass, or delay a fair trial. The court will just strike that material out to preserve the sanctity and focus of the proceedings.
We've established how to construct a perfect pleading, but now we address the scope. We turn to Article 216, the principle against splitting of claims. This rule fundamentally dictates the lawyer's obligation to bring all their clients' grievances forward at once. This is all about judicial economy.
It's a clear and a very robust mandate. Article 216 states that every suit shall be framed so as to avoid further litigation and must include the whole claim the plaintiff is entitled to.
This is the CPC ensuring that the court system and the defendant aren't subjected to piecemeal lawsuits.
Exactly. Not from a single legal event.
What is the penalty for failing to include the whole claim?
The consequence is absolute and punitive. If a plaintiff omits any portion of their claim, they are absolutely barred from suing for that portion afterward.
Forever.
Forever. The underlying policy is to prevent unnecessary burden on the judiciary and to prevent the harassment of the defendant by repeated litigation over the same originating dispute. If you suffer 100 burr in damages, you must claim all 100 burr in one suit.
Is there any exception to this bar? A way to cure that omission later?
There's only one procedural escape route. Article 216(4) allows the court to give the plaintiff leave to sue for additional relief at a later time. But
there's a catch.
There's a big catch. The plaintiff has to convince the court of a valid, justifiable reason for the original omission. Maybe information was unavailable, or a consequence of the action hadn't materialized yet. But this is discretionary and, frankly, very difficult to obtain.
Our sources clarify that the prohibition operates on two fronts simultaneously. Can you break those down?
Yes. The first rule is that the plaintiff must include the whole claim based on a single cause of action. The second is that the plaintiff must seek all the relief they are entitled to based on that single cause of action.
And the key concept tying it all together is single cause of action.
It is. If a plaintiff has several distinct, unrelated causes of action, say a breach of a commercial contract and a totally separate land dispute, they're not bound to join those claims. They can sue separately. The prohibition targets claims that all stem from one core set of facts.
Let's illustrate the application of that single cause of action test. What about ongoing obligations like rent?
This is a practical challenge.
Yeah.
Suppose a tenant owes monthly rent, and the landlord hasn't been paid for January, February, and March.
Okay.
If the landlord sues in April only for the January rent, can they sue for February and March later?
I would guess no.
It depends. The answer depends on when those separate causes of action matured. If the landlord files suit in April, and the rent for February and March was already due at that time, then all 3 months form part of the same current accrued claim. Splitting them is prohibited.
But what if the April rent wasn't due yet when the suit was filed?
Then the April rent forms a separate, subsequent cause of action and can be sued for later. The test is, did the right to sue for that claim exist at the time the first suit was instituted?
Now let's use the powerful example provided in the source material. Strategic relinquishment to meet pecuniary jurisdiction. This is where lawyers make a deliberate, costly choice.
This scenario really highlights the high stakes. Imagine the relevant court has a maximum pecuniary jurisdiction of 500,000 burr.
Okay, hard limit.
but the plaintiff is owed 700,200 birr on a single debt, like a check. To ensure the claim falls within the jurisdiction of that specific court, the plaintiff may choose to explicitly relinquish the excess 200,200 birr.
And once you do that,
It's gone. That amount is irrevocably abandoned. Article 216 prohibits the plaintiff from ever suing for that 200,200 birr portion later. This conscious sacrifice is permanent.
and if a single tortious act, like the negligence we discussed, causes multiple damages, personal injury and damage to a car, is that one cause or two?
That is firmly treated as a single cause of action. The initiating act, the negligent driving, is the legal origin. While there are two heads of damage, the claim must include the whole of the plaintiff's entitlement arising from that single incident.
So if you sue only for the car damage and leave out the personal injury claim?
You are barred from suing for the personal injury later.
Yeah.
The rule is strictly against splitting claims that arise from a single originating cause.
And the bar against omitting relief operates similarly, tying back to the required specificity we talked about earlier.
Exactly. This is the second front of the splitting rule. If a party is entitled to multiple reliefs from the same cause of action, say, they are entitled to the return of property and the accumulated rents from that property.
You have to ask for both at the same time.
If you omit the claim for rents or profits, you're barred from bringing a future suit for that specific relief. The lawyer must ensure every single entitlement, specific performance, damages, interest, costs, is explicitly listed in the relief section of the initial statement of claim.
If you seek one and omit the other, unless you get that rare court leave, that entitlement is waived forever.
Upholding the policy of finality in litigation.
We have meticulously crafted the claim and ensured its scope is comprehensive. Now, we move to the official commencement and the mandatory next step of informing the defendant.
Right. The institution of the suit.
This is the formal moment of commencement.
Yes, Articles 213 and 80 govern this. A suit is formally instituted by the presentation of the pleading in the prescribed format to the court clerk or registrar.
The physical act of filing the documents and paying the court fees.
Usually, yes.
And who is legally empowered to present the suit?
The pleading may be presented by the affected person themselves, by their legal representative, like an advocate, or by a duly authorized person, an agent or pleader who has proper authorization.
Once the statement of claim passes the registrar's technical check and the judge's substantive check, the court has a mandatory obligation under Article 233.
To notify the opposite party.
And this is done via the summons.
The summons is the legal equivalent of a physical knock on the defendant's door. Article 94 defines it as the formal mechanism that notifies the defendant of the suit and calls upon them to appear before a designated court at a fixed time and date to file their defense.
This is more than administrative paperwork. This is the constitutional guarantee of fairness in action.
Absolutely. The purpose is strictly twofold. First, informing the defendant a suit is pending against them. Second, and fundamentally, providing the defendant with the essential opportunity to be heard.
The core requirement of due process.
And a fair trial. Without proper notice, any resulting judgment is fatally flawed.
Who handles the issuance and the content requirements?
The summons can be issued by the registrar or the judge. If you have multiple defendants, a separate, distinct summons has to be issued and served on each one.
And Article 94 dictates what must be in it.
Yes. The name of the plaintiff and their claim, the defendant's name and address, the case number, and practically the total page count of the statement of claim and the evidence attached.
It also has to specify the time, date, and court of appearance.
And crucially, it must explicitly list the materials the defendant must produce on that date, their statement of defense, their list of witnesses, their list of documentary evidence.
So it compels them to be procedurally ready.
It does. And the summons must contain the warning that the case will proceed even if the defendant fails to appear or fails to bring their statement of defense.
Once issued, the summons must be served by a serving officer, but we know that in Ethiopian practice, this task is often delegated.
It is, and this places an enormous procedural risk on the plaintiff.
How so?
Courts commonly authorize the plaintiffs themselves or their agents to act as the serving officers. While this can speed up the process, it introduces a massive procedural vulnerability.
Because if the plaintiff messes it up?
If the plaintiff, acting as the serving officer, fails to effect proper service, meaning the service isn't legally sufficient, they face the sanction in Article 70D, striking out of the suit or dismissal of the appeal.
The case ends not on its merits, but on an administrative failure.
Exactly. The only procedural cure for defective service is if the defendant, despite the defect, voluntarily appears in court anyway.
The legal framework establishes a strict hierarchy for the modes of service: personal, constructive, and substituted. The court must always attempt the most effective method first.
Correct. The ultimate legal test for sufficiency is whether the mode used was the most reasonable or possible under the circumstances to ensure the defendant received actual notice. Insufficient notice directly violates the opportunity to be heard.
Let's start with personal service under Article 95.3. This is the gold standard.
It is. Personal service means physical delivery of the summons directly to the defendant, who then has to sign an acknowledgement confirming receipt. This method is mandatory, unless it can be demonstrated that it's practically impossible.
It establishes irrefutable proof of notice.
It does.
And what about the concept of assimilated personal service? When is service legally deemed personal, even if the defendant's hand didn't physically touch the paper?
This covers situations where the person receiving the summons has a legal or explicit agency relationship with the defendant, which virtually guarantees notice.
Like service on their lawyer.
Exactly. Service on an authorized agent, service on the defendant's pleader, service on a body corporate delivered to a high-ranking officer, service on government officials, service on a partner of a firm. In all these cases, the law substitutes the receiving party for the defendant.
If personal service is impossible, we move to the secondary level: constructive service.
Yes, Articles 99, 100, and 101. Constructive service relies on the high probability that a connected person will convey the notice.
So what are the main situations?
Three primary ones: service on a manager or agent for business purposes, service on the agent in charge for suits concerning immovable property, and service on a responsible adult member of the defendant's family.
And what are the strict preconditions that must be met before constructive service can be ordered?
The court can't just jump to it. It must be proven that two conditions are met. First, the defendant is unavailable and the local limits the court. And second, the defendant does not have an agent specifically authorized to receive the summons.
And if personal service fails, the serving officer has to file an affidavit.
Under Article 103, yes, an affidavit of facts explaining the impossibility. That then allows the court to order the next step.
We should also address service by post.
Yes, Article 106. This is often prioritized because it provides a reliable record. It should really be employed in lieu of or in addition to substituted service. It provides a layer of reliability that simply, taping a notice to a door may not offer.
Finally, the method of last resort: substituted service under Article 105.
This is only used when all other reasonable means have demonstrably failed. It's an acknowledgement that the defendant is actively evading service or is genuinely impossible to locate.
And what does it involve?
Article 105 authorizes three methods, often combined: affixing a copy in a conspicuous place in the courthouse, affixing a copy on a conspicuous place of the defendant's last known residence or business, and publishing the notice in a newspaper.
And the first two are usually done together.
Yes, and all three may supplement service by post or service through another court. There are also special rules for defendants residing out of Ethiopia, but the principle is the same. The court must be satisfied that this last resort is genuinely the best notice possible under the circumstances.
We come to the procedural endgame. If the court, perhaps pressured by judicial economy, proceeds with an insufficient mode of service when a better one was feasible, what happens to the subsequent judgment?
This is the critical high-level insight for our law students. When notice is defective, the resulting judgment is voidable. In Ethiopia, the failure to provide legally sufficient notice is viewed not just as a technical error, but as a fundamental denial of due process.
A denial of access to justice and a fair trial.
That's right. It's codified in Article 70A and 78-2.
So this is paramount. It's not just a technical flaw, it's a constitutional violation.
Exactly. While in some places the court might just lose technical jurisdiction, here, the court has violated the defendant's fundamental right to be heard. The cassation bench has consistently prioritized this fairness requirement over the competing goal of judicial efficiency.
And the result of the cassation bench's analysis is unwavering.
It is absolute. The consequence for defective service is not a simple correction. The judgment is quashed, and the court orders a complete retrial of the case.
A complete retrial.
Yes. The judiciary is sending a clear message. Every proceeding based on flawed service is considered null and void. Regardless of the years of litigation or the amount of evidence presented, procedural fairness is paramount.
Let's spend some time on the specific cassation bench rulings that enshrine this doctrine, as these are the ultimate authority our audience must understand.
These rulings really illustrate the practical application of Article 78-2.
So we have Volume 6, Case No. 354A3, and Volume 9, Case No. 50376.
Those established early on that service failure undermines the entire judicial process. The bench confirmed that if the defendant wasn't legally served, even if they might have heard about the case incidentally, the subsequent default judgment must be overturned.
Then we see further consolidation in Volume 12.
Yes, Case No. 53113 and Case No. 180673. These rulings really explore the hierarchy of service. They emphasize that if the plaintiff or the serving officer failed to exhaust the more effective modes, like constructive service, before resorting to the least effective, like a newspaper publication, then the entire process failed the best notice possible standard.
So the requirement for that affidavit explaining why you couldn't do better became a strict precondition.
A very strict precondition. Finally, we have Volume 23, Case No. 137704. This one reinforced the gravity of the constitutional dimension.
And what did it clarify?
It clarified that due process is an active obligation on the court. The court can't just accept faulty service records blindly. If the record shows a fundamental failure, the remedy is a mandatory retrial. For law students, these cases are the practical proof that the burden of proper procedure lies heavily on the plaintiff, and the judiciary will sacrifice procedural economy to protect the right to be heard.
We have journeyed from the precise formatting of the statement of claim all the way to the ultimate consequence of an improperly delivered summons. What strikes me most is the inherent philosophical tension in the Ethiopian Civil Procedure Code.
The drive for efficiency versus the demand for fairness.
Exactly. That tension is the central strategic challenge for any lawyer, isn't it?
It is. On one hand, you have the strict rules against splitting claims, Article 216, which shows the CPC's absolute priority on judicial economy and preventing defendant harassment. It demands that you front-load every single claim and relief,
Sacrificing potential future claims if you fail.
right. And on the other hand, you have the cassation bench's fierce defensive service and due process, ordering retrial after retrial based on those rulings we just discussed.
Which shows an overriding commitment to fundamental fairness.
It does.
The ultimate lesson, then, is that the procedure is not a suggestion. An improperly served case is professionally negligent. It's a case that, regardless of the client's substantive right, is destined to be quashed and restarted.
Procedural perfection is the only path to a successful substantive outcome. You have to be diligent in filing everything required up front, all facts, all release, and equally diligent in ensuring the defendant receives the best possible notice. Failure in either area is fatal.
Which brings us to our final provocative thought for you, our law student audience, as you consider strategy. Given the court's relatively liberal approach to amendments under Article 91, favoring the rectification of minor defects, and the harsh, permanent penalty for splitting claims under Article 216,
Which bars future recovery.
how should you, as a lawyer, strategically decide in the moment whether to request an amendment to add a specific relief that might have been omitted versus the serious risk of having that relief deemed a barred, split portion of the cause of action? Where do you draw the ethical and procedural line between curing an initial omission and attempting to introduce a wholly new claim that should have been filed separately?
That decision requires not just knowledge of the articles, but a strategic understanding of which defect the court views as more damaging to the adversarial process. Think about that balance as you move forward in your practice.
An excellent point to end on. Thank you for guiding us through this essential deep dive into the legal foundations of procedure.
My pleasure.
Until next time.